Thank you, folks. Members, take their seats. I want to thank the Senate for taking the invitation from the House to come and meet on 2 House bills. I know the Senate goes on general orders today, so they're going to be here late. I'm not very sympathetic, but we'll be having dinner and listening to you. But Mr. Chairman, thank you for coming. Mr. Vice Chairman, Senator Foscato, thanks for being here today. What I propose is we have 2 House bills, House Bill 2137 and House Bill 2252, which we're conferencing on. When they left the House, they were great bills. I'm not sure what the Senate did to them, but I guess we'll find out. And this committee will make them superb. But I would propose that we take Matt or Jason, whoever you prefer, and have them go through the sheet that I had them make up about the comparison between the 2 positions. So Matt or Jason, who wants to take the ball here?
Mr. Chairman, I'll run through the chart if you want of the issues that's been distributed to the committee. I'm going to share that chart now for the folks who are streaming in remotely. Because the Senate put
Can we get the volume up?
Can you hear me?
That's as loud as it gets. Okay, thank you. Go ahead, Jason. Sorry.
I will try and talk louder. Because of the Senate putting several bills together, I worked up the chart more on the policy issues that have passed one chamber or the other, rather than break it down by the bills. But I did include in the chart the reference to the bill and section number where you can find those provisions if you want to look at the language of the provision. So starting on page 1 of the chart, under some general regulatory provisions for regulating alcoholic liquor, you see the first policy was the repeal of the residency requirement for licensure, basically eliminating that residency requirement under all 3 liquor regulatory acts, the Liquor Control Act, the Club and Drinking Establishment Act, and the Kansas Saremont Beverage Act. That same provision was included in House Bill 2252 on the Senate side. The next issue is the issuance of a license when the spouse of the applicant is a law enforcement officer. The House's version exempts the spouse's ineligibility due to being employed as a law enforcement officer in general. The Senate position was similar, except that it only applies if the spouse is a law enforcement officer in a county other than the one where the licensed premises will be located. So there is a qualification on the exemption under the Senate position. The next issue there at the bottom of page 1 are authorizing, changing the hours of sales on Sundays and authorizing sales on certain holidays. The House position authorized the sale of alcoholic liquor and cereal malt beverage on Sundays from 9 a.m. to 8 p.m. It also authorized sales of alcoholic liquor by retailers on Memorial Day, Independence Day, and Labor Day. The difference in the Senate is that the hours of sales on Sundays would be 10 a.m. to 8 p.m. So there is a time difference between the 2 chambers. Moving on to page 2. This isn't a issue that has passed the Senate in Senate Bill 2. It's the State Fair Consumption Area provision that authorizes the State Fair Board to establish an area on the state fairgrounds for consumption of alcoholic liquor and cereal malt beverage sold by licensees who have a leased premises at the state fair. The area must have a physical barrier and signs identifying the area. And then there are provisions that 70% of the taxes derived from such sales are to be credited to the State Fair Capital Improvements Fund, provided that the state fair remains located in Hutchinson, Kansas. Then moving on to some provisions that are more specific to Liquor Control Act licensees. There are provisions in House Bill 2252 to authorize the issuance of a fulfillment house license. The House position was to issue a license to each premises that is involved in fulfilling special order shipments of alcoholic liquor for delivery direct to the consumer. It's a $50 fee for each license. The licensee must comply with all packaging and labeling requirements and maintain records of shipments. The same provisions were passed by the Senate and Senate substitute for House Bill 2252. Moving to page 3. The next provisions were provisions that were added into House Bill 2252 by the Senate. The first is the transfer in bulk of wine and spirits by farm wineries that hold a federal TTB permit. It prohibits the transfer of bulk wine to a brewery as prohibited by federal law. The next provision is the repeal of the 30% Kansas-grown product requirement for farm wineries and microbreweries. That current statutory requirement is stricken under Senate substitute for House Bill 2252. Along with that, there is an authorization for farm wineries to import wine from other jurisdictions for use in production. The next issue added by the Senate is a provision to require special shipping order licensees to pay their gallonage taxes that they collect electronically and on a quarterly basis. And then there is a provision added to 2252 by the Senate authorizing the receipt and transfer in bulk of alcoholic liquor by a packaging and warehousing facility permit holder or the holder of a federal distilled spirits plant permit, basically to do that for purposes of canning and bottling. And there is a technical amendment the conference committee that was suggested by the director of ABC to authorize the producers of these alcoholic liquors to transfer their product to the packaging and warehousing facility permit holder for purposes of canning and bottling. On to page 4, there was a provision in House Bill 2417 to authorize licensed retailers and clubs and drinking establishments to sell beer and cereal malt beverage in refillable and resealable containers. These are commonly known as growlers, as squealers, howlers, etc. Also establishes that such sales by clubs and drinking establishments cannot occur after 11 p.m. The Senate has the same provision in Senate substitute for House Bill 2138. That is above the line scheduled for floor debate today in the Senate. The next set of provisions deal with club and drinking establishment licensees in particular. The first is the sale of cereal malt beverages by clubs and drinking establishments. This is House Bill 2137. It would allow a licensed retailer and licensees under the clubs and drinking establishments that are licensed under the act to sell cereal malt beverage and beer containing not more than 6% alcohol by volume. This would go into effect on July 1st, 2021 under the House version of House Bill 2137. The Senate adopted the same substantive provisions, but set the publication date on publication in the Kansas Register under the amendments to House Bill 2137. Moving on to page 5, the provision in 2137 regarding pickup of alcoholic liquor at a club and drinking establishment repeals the March 31st, 2021 expiration date on that authorization. Under the House bill, it also authorizes the sale of alcoholic liquor and cereal malt beverage in the original unopened container, but limits such sales to occurring before 11 p.m. And then exempts beer, wine, and cereal malt beverage and mixed drinks that are not in the original container from the drink size requirements under the Club and Drinking Establishment Act. The Senate has a slightly different version. It also repeals the sunset It also authorizes the sale of alcoholic liquor and cereal malt beverage in the original unopened container, but excludes spirits from that authorization, and then prohibits sales after 11 p.m. except for partially consumed bottles of wine that have been purchased on the premises. The next issue was in House Bill 2057, passed by the House, was authorizing a licensed manufacturer to hold one drinking establishment license. The caveats on that is the drinking establishment must be at least not more than 2 miles from the manufacturer's licensed premises. And all alcoholic liquor and cereal malt beverage sold by the drinking establishment must be acquired through the 3-tier system from the distributors or the retailers, farm wineries who are allowed to self-distribute. The Senate has the same provision in Senate substitute for House Bill 2252. Moving on to page 6, the last page, there is provision for sales of alcoholic liquor at special events by a Class A club licensee. This was in Senate Bill 126 that came from the Senate. It defines an event as requiring notification be sent to the director at least 48 hours prior to the event, but it would allow the Class A club to sell alcoholic liquor to people other than their members, families, and guests, which are the typical limits for Class A clubs. And then there is the next provision is the sale of pitchers of alcoholic liquor by clubs and drinking establishments. This was an amendment added to Senate Bill 126 in the House that has not passed either chamber. It was mistakenly included on this chart because it has not passed either the House or the Senate. It was a committee amendment to 126. And then finally, there's a provision for approval of a CMB retailer license for an applicant who's already holds a producer license under the Liquor Control Act. This provision in House Bill 2406 on the House requires that if the applicant is otherwise eligible for a CMB retailer's license and holds a producer's license issued under Liquor Control Act, and then the application for the license is to be approved by the Board of County Commissioners or the director as appropriate. That same provision is included in Senate substitute for House Bill 2138. That is all the issues thus far. This chart is potentially subject to change. However, as I said, because the Senate is scheduling House Bill 2138 for floor debate today. I'd be happy to answer any questions.
Thank you. Thank you, Jason. Questions for the reviser? Yes, Representative. Senator, go ahead, please.
Thank you, Mr. Chairman. So, Jason, if you could please give me a definition of producer.
Oh, the producer, that is a special license under the Liquor Control Act that allows it's a special statute authorizing a special license under certain conditions for an entity to sell and serve alcoholic liquor. And I'll have to quickly look at the statute here to tell you what those conditions are. If I can find it in just a minute. So basically, if the person is engaged in a business as a vineyard with not less than 100 vines of grapes or other agricultural, or is an other type of agricultural producer with an annual harvest of at least 1,000 pounds of other fruits or berries or 1,000 pounds of honey, can get up to 2 producer licenses. So basically, these are home vineyards and fruit and honey production that they want to produce, that they use their product to produce a type of alcoholic liquor, and then they can then sell and serve that alcoholic liquor on their licensed premises.
Okay, Mr. Chairman, just one more. Jason, and what's the, your definition of Class A clubs? Thank you, Mr. Chairman.
Yes, the Class A clubs are defined under the Club and Drinking Establishment Act. Um, uh, Basically, it's a nonprofit social, fraternal, or war veterans club, kind of like a VFW club, that has exclusive membership, and basically is limited to selling alcoholic liquor to their members and then members' families and guests who accompany them to the club.
Thank you. Jason, got a question here. Senate Bill, you cite Senate Bill 2. Where is that bill at?
Yes, Senate Bill 2, I just saw today, was referred to the House Committee on Commerce, Labor, and Economic Development.
Okay. So it has not passed the Senate?
Well, Senate Bill 2 passed the Senate, and so the contents of Senate Bill 2 regarding the state fair consumption area has passed one chamber, but then it was referred to the House Committee on Commerce.
Okay. And House Bill 2057. I didn't have that in my committee, so.
Yes, so that came over to the Senate from the House, and the Senate took those provisions and put them into, I believe it was House Bill 2252. So I believe that one, yeah, when the Senate substitute for House Bill 2252.
What committee did it come from?
I believe it came from House Commerce, Labor, and Economic Development, but let me check real quick. Yes, yes, it did.
Commerce. Thank you. Other questions for Revisor, Mr. Chairman?
Jason, question that I had was, I do have an amendment that I'd like to add on later. And if I am reading this right, it would be on the bottom of page 3.
That's correct. Yes, it's a technical amendment to the provision that authorizes the receipt and transfer of bulk alcoholic liquor for canning and bottling purposes.
Thank you.
Thank you. One other, on page 6, the sale of pitchers of alcoholic liquor by clubs and drinking establishments. That was an amendment that was put on Senate Bill 126, but that language has not passed either body, correct?
That's correct. It was mistakenly included in the chart. I thought it had passed one body, and I was corrected this morning that was simply a House Committee amendment that has not passed either chamber.
So that could not go in a conference committee then?
Not currently, no.
Thank you. Further questions of the revisor? Yes, Representative Reese.
Thank you, Mr. Chairman. Jason, can you describe or define bulk wine and bulk liquor? Is that, are those shipped in casks, big bottles? How's that done?
Yes, those are basically transfers that are done under a federal TTB permit. So really relying on federal regulation for those activities in terms of what is a bulk container and what ship. It is basically large volumes of shipment of alcohol, of wine and distilled spirits under those permits that the licensee holds from the federal TTB. I can get you information if trying to see what the federal regulations have on those bulk transfers and get that information to the committee.
Thank you, Jason. Thank you, Mr. Chairman.
Do you want him to send it to the committee?
So if you would send it to Connie, and then if she could distribute it, that'd be okay.
Will do.
We have two Connies, Connie.
Either one.
or both. Further questions? I just have one more. Existing law, and that's, go to page 3. In the Senate version, they repeal 30% Kansas homegrown products required for farm wineries and microbreweries. And it authorizes farm wineries to import wine from other jurisdictions for use in production. Are those, when you say import, is that from in-state wineries or out-of-state wineries?
It would
If
be
you know.
importing wine from outside the state of Kansas.
So when you go to a vineyard and you want to taste their wine, you may be tasting California wine then.
A portion of that Kansas wine, yeah, could come from wine that was produced in California or another state, yes.
Okay, thank you. Further questions of the reviser? Yes, go ahead.
Jason, on that same subject, is that wine or was that the grape product that was, or the fruit that was being imported?
Farm wineries already can import a portion of their grapes. That's what the 30% requirement kind of limits on imports of the grapes. The new provision that is being added under House Bill 2252 was allow the licensee to import wine from outside of Kansas for use in the production of wine by the licensee. And those imports would be required to be reported to the director.
Thank you.
Thank you. Yes, Senator.
Thank you, Mr. Chairman. So Jason, just clarification on that. So if we're repealing the 30% required, then is there another percentage that would be required?
No, with the repeal of the 30% Kansas grown product requirement, a farm winery could import 100% of its grapes from outside the state of Kansas, the production of wine. And with the microbrewery, it could import 100% of the agricultural product used in the production of beer by the microbrewery could come from outside the state of Kansas.
Thank you. Further questions of the reviser? Okay. Thank you. If you'll stay on, at some point in time, Jason or Matt, we have 2 conferenceable bills. We would like a recommendation from you of where they would fit in each bill, each of these proposals, from the Senate's version to the House version. I would imagine that under 2137, you would have a number of what would, from the Senate's version, what those would be subject matter related, and then in 2252 would be the same. Just a proposal or how you think it may work. And
yes, we can provide that, Mr. Chairman. I think the other thing the conference should consider is 2137 has an effective date of Kansas Register. And so all the provisions that are currently under that bill would go into effect earlier than the provisions that are currently in House Bill 2252, which has a July 1 effective date. So the conference committee can also consider when they would like different provisions to potentially take effect.
Thank you. And I'm looking at the chairman on the Senate side, and that's probably the first thing we can agree upon. We'll work a date.
I think that, thank you, Mr. Chairman. I think that if we go to page 5, we do have a date that we've already missed, March 31st on the top. And so that's
the effective date of the repeal, but the effective date of the bills would be, right now they're different, and you would probably like to have them the same, correct, Matt or Jason?
It depends on the provision. That provision, the Chairman Alley referenced, I think had a Kansas Register effective date to try to put it as close to that March 31st expiration as possible. Other provisions have a standard July 1 effective date because there was no circumstances like that with those other provisions. So it's really a policy decision for the conference committee to decide.
Mr. Chairman, have you got a proposed date on that? As soon as in the
As
register?
soon as it's registered would be fine with me.
All right.
And
I mean, the expiration date is come and gone.
yes,
We
so
don't
we want to,
penalize them
as soon
anymore.
as possible.
As soon as possible. Okay, thank you. Anything else for the reviser? Good, let's, I can make this easy. The Senate can just concede to all the House views, and we'll take yours up next year, the Senate's views. Would that be, do we have?
I think you know the answer to that. I would like to,
You got it, you can't blame me for trying.
right? I would like to introduce the amendment, so I don't forget it again. And I'd like to, this amendment basically allows for the warehousing and packaging facility permit holders to receive alcoholic liquor for purposes of canning and bottling. The amendment is a technical amendment to authorize the alcoholic liquor producers to transfer the alcoholic liquor to and from the canning and bottling facility. The amendment was recommended by the director of ABC to ensure that the manufacturers and the wineries and breweries have the authorization to do so. And that amendment on the floor was S 1905.
Thank you. I'm looking at my members. I don't think we have a problem with this amendment. It is a technical amendment, so we will accept your amendment to the final product.
Thank you.
You're welcome, sir. Just to go back to page 1, the residency requirement, I think the Senate's position is much like the House position on that. I think the House could probably accept that. So I'm just going to put a check mark beside that, and if we have some other issues, we could.
Okay.
The second part, the issuance of license when spouse is a law enforcement officer, we have it where there's no limitations. Of course, you've put in that they can't do it if their husband is a law enforcement officer in that county. So that issue, I'm going to look to my vice chair. I think she has a comment about that.
I don't think, Mr. Chair, it doesn't say, does it say husband anywhere? It just says spouse. Yeah, I just think in general, we need to go with the House position on that one. There's really no need for it in the first place, so.
What is the reasoning of the Senate?
The reasoning for that in the Senate, and it was very important to several members of our committee, was that to eliminate improper influence, perhaps. If a spouse was a law enforcement officer and they had an issue enforcing the law on a deal, so it's best if they were from a county outside of the one which the establishment was in.
Okay, we'll come back to that.
Okay.
Let's go down to the Sunday holidays and sales times. We have 9 o'clock. You have 10 o'clock. Not a great difference. Senate's reasoning for the 10 o'clock? Only for the Senate. The House is up early. Representative Reese, you're from that area?
Thank you, Mr. Chairman. And we debated this 10 o'clock was our initial start time on the Sunday sales for liquor stores. But being from a border county, border city, And during football and baseball season, the games on Sundays, a lot of revenue goes across the state line. So we felt that at 9 o'clock, our liquor stores would be better, because if they're going to bring somebody at 10 o'clock, they might as well bring them in at 9 o'clock, make that extra revenue to get those people across the state line to the games and function and events a little bit earlier. We felt to accommodate that. That's why we moved it to 9 o'clock.
If I may ask a question, what time do the big box stores open?
Well, the big box stores in our area don't sell liquor or wine. They sell beer.
Well, I'm talking about across the line.
10 o'clock and 11 o'clock on Sundays sometimes. Some of them do. So, but your Quick Trips and them open at 9 o'clock. Your chain liquor stores over there like Crown Liquor, Happy Hollow, and then they'll open at 9 o'clock to accommodate the traffic and the demand of alcohol on Sundays.
We're going to come back to that one.
Very good. We'll come back to that. I would want to state that initially our bill had 10 o'clock. It was an amendment brought in committee. We've heard the same argument, especially from, we have members that are on the border states, and they wanted to work and have the same hours as Missouri. So, but we'll come back to that one. The state fair consumption area, it was not in any of our bills. You've added it in. You have.
This bill was brought to us by former Senator Ed Berger, who is now acting director of the State Fair Board. And today they have an area that you can go buy your beer and wine and go out in a designated area that is marked off and sell and consume there. They would like to either add additional vendors or increase the size of the drinking area. And I've asked Senator Berger about it would not be down the midway. It's going to be a designated area, and it definitely would not be in any buildings. It'd be out in the open area there. It would be designated. What they want to do with this is 70% of the taxes derived from such of those sales would go to their capital improvements, which they definitely have some capital improvements need to be. So we would recommend that we go ahead with this one.
Thank you. And I'll look to my ranking member. I think we had a bill like this before, didn't we, Chuck? Yeah. And we did not pass it, correct? You heard it, but never passed it.
Mr. Chairman, I do have a question. Is there, in these restricted or designated areas, would there be an age restriction on that? Would children be allowed to go in with a parent?
Same as what it is today. They have one out in there today, and I think I don't really know what the age. I'm assuming it's the age you can buy liquor. But they're
Just to be in the area.
I don't know that.
Something we could.
Can we ask Jason or Matt to look into that, Matt or Jason?
Certainly, Mr. Chairman. Yes, we will.
Okay. Now, we allow that for cities to have special events and have those marked off areas. I would assume, could be wrong, is that they have some statutory language in that part of the law that we could look at if we don't have it in this.
My understanding it'd be the same as what exists today. So now whatever that is.
See, if you could get us that information, I would appreciate it. And also a definition of what a physical barrier is. Is it just is it a fence, or where people can reach over and get drinks, or is it a wall? If you could give me some definition that we presently use in that area. Is that agreeable, Matt or Jason?
Yeah, we can check with the director and see what they would be looking at in terms of enforcement of that physical barrier requirement.
Thank you. If you get us that information, get it to Connie and Connie. And the 70% tax deprived from such sales to go to the State Capital Improvement Fund, provided State Fair stays in Hutchinson. Do we think it's moving from Hutchinson?
No, it is not moving from Hutchinson. In fact, if it does ever move from Hutchinson, this goes away. So.
I wondered why that was in there, but okay. All right, let's go down to fulfillment houses licenses. You have the same as we have, except you've added in sections 1 and 2 of 2252. Would that, okay? I don't think we're going to have any problems with that one. Bulk transfer of wine and spirits by farm wineries. From my side, any questions? And I think this is something that the House has not seen. So I think we're going to have a little bit more discussion and a little bit more definition along with the second session. I remember when we passed the 30% Kansas-grown products required for farm wineries and and we did that for a reason, to help Kansas wineries, and then we allowed them to serve wine on the premises. So now, do they even have to grow grapes to have a winery? I don't know that.
With this, excuse me, with this provision, they could import their wine or their grapes from another location.
You go to a winery and you don't get to look at the wines or the grapevines or anything. You just open a winery and say it's a winery without growing any grapes.
I'm not sure that you'd have a winery if you don't have the grapes. I think the issue.
But there's no requirement.
Right, but the issue here is, for instance, down in Mulvane area, there's a winery that has the elderberry. He's growing elderberries, but if he wanted to incorporate and bring some grapes in from another location, that's what he's wanting to do. So that's basically the reason for that.
Okay, that's put a big question mark on that one, the House position. And I've got to go back and convince 63 of my friends. And that may be a large burden. So we'll go down to special shipping.
Senator Foscato has a question.
Oh, I'm sorry.
Thank you, Mr. Chairman. I too remember the discussion initially about the 30% of the grapes and that product grown here in Kansas. So can I ask Jason, can you tell me what was the reason that we want to change this? Are we not producing enough to eliminate the 30% requirement?
Senator, the percentage requirement for Kansas-grown products for farm wineries was originally higher than 30%. It has been reduced through legislation in past years down to its current level of 30%. I am not aware of the particular reasons behind the amendment that repealed the Kansas-grown product requirement altogether that was adopted in the Senate. I don't know if there's a particular case or if there was concern about being able to produce enough product in Kansas. I just don't have that knowledge, but it has been reduced down from its initial percentage requirement when it was first enacted down to the current 30% over the years.
Go ahead.
Would it be possible to have someone to tell us what that would be?
You mean Tuck?
Yes.
Oh, okay.
He had a bigger title last time.
It is now. Tuck Duncan, Wine and Spirits Wholesalers. The Attorney General issued an opinion that this provision is unconstitutional. There have been several federal court cases, went to the U.S. District Courts of Appeal, hasn't been to the Supreme Court, declaring it unconstitutional in other states. And so the conundrum is, does the state enforce it or not? And And if you do away with the 30%, you need to understand you can't call it a Kansas wine unless it has 75% Kansas product under federal law. So you might be able to put on the label, you know, bottled in Kansas, but you can't say Kansas Cabernet Sauvignon if it's got less than 75% fruit. That's the kind of the control in this thing. So that's why it's in there, though, the constitutionality.
Okay, and could you send Connie that AG opinion, the number? I will get it.
I can.
All right. So we can, all right, spend enough time on this. Go to the next section, set commencement date for special order shipping license as a date specified on the license, requires licensee to remit gallons tax electronically. That's and I'll wait to hear from my vice chair and ranking member. I don't think there's a lot of controversy as to this. I mean,
I
it's
think
just
that was a
reporting it
a request from ABC.
from ABC. Okay. I don't think we need to talk about that next time. So if we go down to bulk transfer of alcoholic liquor for canning and bottling, authorize issuance of packaging and warehousing facility permits to be holder of a federal distilled, okay. Authorize a packaging and warehousing facility permit holder to transfer and receive alcoholic liquor in bulk. Again, we go back to bulk. Is that like barrels or?
I don't think it's barrels, but it could be. But this was so that we do have a canning facility that's being proposed and is, I think, it's going to be in your area in Manhattan. And this just allows that to proceed with canning. And that's the reason for the amendment, was to tack on at this location.
Okay, is that like liquor covered cherries or whatever
No, they put it in cans,
oh, okay.
the wine in cans, and
In cans.
yeah, in it's Manhattan, Kansas.
French hear about that, they'll commit suicide, putting wine in cans. Well, anyways, all right, that's an area we can talk about. Authorized licensed retailer clubs. This is the growler, and we're on the same sheet of music here. So I don't think that's going to be a problem.
I've got a question on
Yes.
that, and if I will, could we introduce your amendment, Scott, on this one? Or do you want to do that this afternoon?
Scott Schneider at the Kansas Restaurant and Hospitality Association. I think the challenge is the language in the amendment hasn't passed either the House or the Senate. So.
Thank you.
And by our joint rules, we can't do that. It would have been nice had we been able to run the Senate bill, but other than that, basically, we're on the same sheet of music there, so I don't see any problems with that. Sale of Saremont beverage by clubs and drinking establishments. You have the same effective date in the publication of register, and you put House Bill 2137 as amended. I don't anticipate any problems on that.
Okay.
Curbside pickup. We're basically the same. We've got the 11 p.m. You've added in the partially consumed wine, which means they put it in a sealable container so you can take it with you from a restaurant rather than drinking the whole bottle. Yes, go right ahead.
Thank you, Mr. Chair. I'm looking at where it says no original unopened containers of spirits can be removed from premises. Was this happening and that's why it wasn't in there, or why did you guys add that?
My understanding, let's say you went to pizza establishment, you ordered pizza in a six-pack, and you drank 4 beers. Originally, they had to open the beers, all of them, all 6 of them. And then they'd have to close that beer up somehow and then seal it back up to take it out. So that's the reason for that, but they had to open the container.
So that, even though it says spirits, that's the same thing as beer, technically?
That's my understanding.
Jason, if you could give us a definition of both spirits, and would it include both spirits and cereal malt beverage?
No, Mr. Chairman, that provision added in the Senate would prohibit unopened containers of spirits, which are defined as hard liquor, what you think of as whiskey, vodka, those hard distilled spirits. So an original unopened container of those types of alcoholic liquor could not be sold and removed from the premises under this provision. Only bottles of wine, cans of beer, bottles of beer, unopened, could be removed from this. And then mixed alcoholic beverages, such as a bottle of margarita mix, I believe could be removed under these provisions.
Go ahead.
Okay.
All right. But all the other portions are very similar to the House. If my vice chair wants to discuss that later, we'll leave it open. Issuance of one drinking establishment license to a licensed manufacturer. Again, we are on the same sheet of music, so we can accept that. Sale of alcoholic liquor or does the Senate have anything this morning that you need? I notice we're getting close to 9 o'clock.
I do have a 9:30 I have to be at, so.
So we also have a calendar, so you mind if we go a little bit longer? No. Okay. Sale of alcoholic liquor at events by a Class A club licensee. We have the same in Senate Bill 126. It passed the Senate. We're willing to take that and put it on the conference committee. Okay. We found it to be without the amendment that we added, because it has not passed either body. Yes, go ahead.
Thank you, Mr. Chairman. Can you refresh us on what your amendment was?
It was the amendment that I think it had to do with the one we previously talked about, that it's not in either of our bills. Yeah, go ahead.
It has to deal with basically defining with to-go liquor. It's stated in statute right now that only certain types of mixed drinks are allowed to be taken out. And so this just goes in, this is compromised language from the ABC director and with Scott Schneider. Because what happened, a restaurant got cited for a bucket of Long Island iced teas, and that is not what is written in the statute. It must be approved by the ABC director. So that's what this amendment does, is just clean up that language and allow Long Island iced teas to go.
And it was brought at the last minute after this incident occurred, and there was some compromise language between ABC director and Mr. Snyder. We put it in. Of course, the bill hasn't went across the floor, so there's no language out there to put in conference committee. However, the original bill, 126, we had hearings. We passed it out unanimously in or on a voice vote in committee. It's just below the line. We do not think it's going to get above the line. So we think it's a good bill, so we would be willing to accept that.
Yeah, thank you.
Okay. Yeah, the one below that was not included in any bill. So that was the amendment, about a 32 and a 64 ounce. Last part is the approval of Saremont Beverage retail license for licensed producers. You have the same language that we have, but you added in Senate sub for HB 21, Section 7. Matt or Jason, just give me a review of Section 7. has not passed the Senate?
Mr. Chairman, it's the exact same provision as in 2406. It just simply has not passed the Senate yet, but 2138 is up for floor debate in the Senate today. So if 2138 passes, then the same provision will have passed both chambers.
Then if it passes, it'll be in. If it doesn't pass, would you, you'll accept our version then?
More than likely.
Okay, good. Trying to be an optimist here. What I'm going to propose is I'll meet with my committee, and you meet with yours, and we'll call another meeting and try to get this thing resolved at the next meeting.
Sounds good.
Okay.
Thank
Mr.
you.
Chairman. Thank you, Mr. Chairman. I would like to try to maybe do this before, I'd like to run this Friday if possible. If we can get to,